Hello friends, how are you? Today in the present lecture series I am going to discuss those cases of the prosecution which are based on circumstantial evidence. Circumstantial evidence means no one directly observed the case, and from the evidence gathered the conclusion of guilt of the accused could be drawn. So basically, if the case is based on a circumstantial evidence, the prosecution has to prove the motive, the connecting chain, and apart from that the chain should not be broken, so that the hypothesis of guilt could be drawn in a very easy way. So when the case is based on circumstantial evidence, the burden is more and more on the shoulder of prosecution, because even a minute mistake inter alia broken the prosecution case or inter alia crack out the prosecution case, and definitely the defense gets the benefit. So topic is quite important for the defense lawyer. It is quite important for those who are contesting the case from defense side. What you have to do, just listen the lecture carefully, note down the important point on the register or the copy maintained by you, and if in near future you are having the same problem, you may use the notes to get rid from the same. Apart from that, the Hindi and Punjabi version of this video is also recorded so that the concerned persons could know the law in their own language. Being a defense lawyer, it is my aim to educate India so that every person could be aware about his rights without getting worried. So the topic is quite important. I am going to start the presentation, and my video is based on judgment of Honorable Bombay High Court, wherein the principle has been discussed to deal with the cases based on circumstantial evidence. Let's start the topic. Friend, in this case, the judgment is passed by Honorable Bombay High Court. Judgment name is Manohar versus Nitin. So these are the basic detail of the case, and the judgment is pronounced recently by Honorable Bombay High Court. Judgment date is 10th of April 2023. Now we are coming on the facts of the case. What are the facts of the case? This appeal is filed by the complainant, father of deceased, challenging the judgment and order passed by the concerned sessions court, whereby the accused person has been acquitted. So by the bare perusal of these three lines, it is quite clear to us that the trial court has acquitted the accused because the prosecution has failed to prove the offence beyond reasonable doubt. Ultimately, the appeal is filed before the Honorable High Court by the concerned complainant, means the father of the concerned deceased, to challenge the order of acquittal, and it is requested to set aside the same. In this case, the accused person has been prosecuted for the offence punishable under section 302, it means for murder, and section 34 with 120B of IPC. It is submitted by the concerned appellant that the trial court has committed the error in acquitting the accused person. Even though prosecution succeeded in proving the circumstances of last seen together, because it is usually emphasized in the murder case, but the key point is that the last seen does not means the conclusive proof. Still, it is yet to be proved by the prosecution, and apart from that, the prosecution has to prove that the concerned accused are the only person who are last seen in the company of the concerned case. If it is not proved or cannot be ruled out, in that scenario, the said circumstance would not avail any benefit to the concerned prosecution. The key point is that the deceased was having love affair with accused number 1 Nitin. He would submit that there was a clear-cut motive proved by the prosecution, as Nitin performed marriage with another woman 1.5 months prior to the date of incident. Since the relationship between Nitin and deceased continued but in the form of clashes, it means the Nitin performed the marriage and the same is not recognized by the deceased. Inter alia quarrel between the concerned complainant and the concerned accused resulted in the clashes, and finally the Nitin is having the strong motive to kill the concerned deceased. Apart from that, the allegation is that the threats were given by accused number 2 and 3 to the complainant and his family members. He submitted that the motorcycle on which Nitin and deceased were seen together were also attached. He submitted that circumstances were sufficient enough to point out finger against accused person. But trial court, while overlooking all the material, had acquitted the accused and therefore committed error. That is very important in acquitting the accused person. So all of you now cleared on the factual of the case. The concerned counsel appearing for the respondent supported the finding of the concerned trial court and submitted that the prosecution failed to prove the case which is based on circumstantial evidence. That is very important and very clinching point averted by the concerned counsels. And he submitted that the circumstances found broken at many stages. Even the story of last seen together is not established conclusively. That is very important. And he submitted that the complainant, when gave missing report, did not even raise any suspicion about the accused person. More specifically, Nitin, which clearly goes to show that the content of the FIR are only an afterthought version. This court should have the enough reason to disturb with the finding of the acquittal and should show the indulgence for having the interference. If two views are possible, the view in favor of the accused should be adopted. The concerned APB of the state also supported the finding of the concerned trial court, but he submitted that at least one of the accused was last seen with the concerned deceased, and that's why he prayed for the conviction in respect of him. The primary key is that the court has to decide whether prosecution succeeded in proving, that is very important, accused number 1 to 4 has conspiracy and in furtherance of which they committed murder of deceased with a motive to protect the marriage of Nitin. You have to remember one thing, that whenever the case is brought before the court frames the charge. And charge means the cause of action, the point to be determined. So in the present case at hand, the point to be proved, as I told you earlier, the prosecution whether succeeded to prove whether there has conspiracy and in furtherance of which the murder has been committed. And after the court examined the entire case, court is of view that it is a case of the prosecution, the accused number 1 and the deceased were in love affairs. Subsequently, the marriage of Nitin was performed with another woman. Despite of his marriage with another woman, the relationship between accused number 1 and Neetu continued, which resulted in frequent quarrel between the two families. Accused number 2 and 3 threatened complainant and his family members and warned them to control Neetu, means deceased, failing which the consequence would be deterrent. This meeting took place on 9th of August 2011 as awarded in the prosecution case, means the date on which the accused number 2 and 3 came to the house of complainant. And on 11th of August 2011, deceased Neetu was not found in their house. Therefore, search has been started. At the inception, the complainant lodged a missing report, and later on the dead body has been recovered on 14th of August 2011 near temple in Anala. Therefore, the concerned complainant lodged a report against the accused person, and finally the affair has been lost. But these facts are clear to reveal that. These facts are clear to show that the complainant has not seen the alleged incident. Rather than it is based on circumstantial evidence, and on the basis of circumstantial evidence, by presuming that the concerned accused are involved in the crime, the FIR has been registered for the offences punishable under Section 302, Section 34 of the IPC, and finally investigation has been completed and accused has been charge sheeted. Prosecution examined the witnesses and also submitted documents, but the circumstances on which the prosecution relies are as follows. Number 1, the accused number 1 Nitin and deceased Neetu were in love affair with each other even prior to the marriage of accused number 1. The relationship has been continued even after the marriage of Mr. Nitin, which resulted in friction between them and their families. And accused number 1 was last seen with deceased Neetu on 11th of August, and seizure of motorcycle and clothes of accused number 1, seizure of mobile phone and SIM card from accused number 1, and seizure of another SIM card at the instance of accused number 1 are sufficient circumstances to connect the accused with the crime. The appellant, as submitted earlier, strongly submitted that the last seen theory has been proved, which is sufficient to hold the accused guilty. And apart from that, the accused totally failed to explain the incrimination in his statement as per Section 313 of CRPC. The court submitted that in this regard, and before going to the merits of the matter, we have to clarify that the present appeal is against the decision of acquittal, and therefore the parameter to be borne in mind as laid down by Honorable Supreme Court are as under. There is a presumption of innocence in favor of accused, and such presumption get strengthened, that is very important, by the order of acquittal passed in his favor. Accused person is entitled to get the benefit of reasonable doubt when it deals with the merits of the appeal against the acquittal. The power of appellate court is not limited. It may convert the finding of acquittal in the conviction or finding of conviction in the acquittal. But the concerned appellant has to show that the concerned trial court has failed to apply the mind and there is a reasonable scope for the interference. If these circumstances are not available on the record and the concerned appellant totally failed to show the erroneous view of the concerned trial court, in that scenario, the appellate court should refrain from interfering with such judgments. Merely because re-appreciation is possible, re-evaluation is possible, the court could took a different view is not justified to set aside the acquittal. Keeping in mind the position of law, the court clarified that the conclusion reached by the concerned trial court is based on the reasonable grounds. The concerned appellant failed to show in which manner the judgment is impugned and it is based on the erroneous view. If such circumstances are not specified, in that scenario, the guilt of the accused could not be assumed. In the present case at hand, the material available on the record are totally failed to connect the accused with the alleged crime. There is no evidence for the crime, and apart from that, the connecting evidence theory are not reasonably put up by the concerned prosecution, on the basis of which the reasonable conclusion could be drawn. If the material collected by the concerned agency are not a connecting evidence, rather than it is a waste piece of bundle of lies, in that scenario it could not be relied upon to convict the concerned accused. So, if the case is based on circumstantial evidence, the prosecution has to prove the guilt of the accused, number one, beyond the reasonable doubt. Apart from that, the fact so established or so put up should be consistent so that the guilt of hypothesis could be drawn. And apart from that, they should not be explainable on the other hypothesis except the guilt of the accused. And another one is that the circumstance should be of conclusive nature and tendency, and it should exclude every possibility of hypothesis except one to be proved. And the chain of evidence must not be broken. If it is broken and going to interfere with the innocence of the accused, in that scenario, the accused will get the benefit. So, looking into the facts and circumstances, looking into the legal position, the inter alia, the court rejected the appeal on two grounds. Number one, the presumption of innocence in favor of accused, and after getting the acquittal, it got strengthened. And apart from that, the appellant totally failed to show the circumstances by the basis of which it could be said that the trial court was totally erroneous for drawing the conclusion in the case. If these circumstances are not available on the record, in that scenario, the finding of acquittal is totally justified and appeal is liable to be dismissed. So friends, in the present case, the court has expounded the various principles and also expounded the law related with the power of the appellate court. I hope that this video and lecture series is totally helpful to you. Please watch such videos to enlighten your knowledge in the field of law. Because you must remember that excuse of law or ignorance of law is no excuse. So be ready with the legal position, be acquainted with the recent legal position, so that in the near future, if you or your relative are having the same problem, your workout, your notes could be helpful even for them. And I also request all of you to share this video so that if anyone is having the same issue, he could be enlightened and could get the remedy from the content specified in the present video. Friend, for such updates in law, please subscribe my channel. See you in the next video. Till then, Jai Hind, Jai Bharat.